All right. Let's see. Let's get everybody on and we'll get started. Ben looks like he's joining us now. And Steph should be joining us in just a moment. Thanks for joining us today, Ben. I always appreciate your time. And let's take a look at today's topic. So overall, today's topic is really about the differences and kind of the thought process behind, hey, we have options on which state we want to form a trust in. Maybe there's a difference in the way that a trust is going to be treated between states and different advantages and disadvantages depending on where people reside, maybe where the property is. So while we're waiting for Steph, we can just talk a little bit really lightly and touch on a couple of big picture things about trusts. Um, Ben, can you talk a little bit about what exactly is a trust, big picture?
So the probably the most oversimplification of it, which helps people understand, is anytime you name somebody to be in charge of any piece of property, money, whatever that might be, for the benefit of somebody else, that's a trust. So if you name uncle or brother or somebody along those lines to manage something for your children or for someone else, that's considered a trust in the eyes of the law.
All right. So and big picture, how are trusts, if you walked into an attorney's office, right? Um, how detailed usually is that consultation? When you're doing the consultation, how detailed do you get when you're doing that initial intake, gathering the initial information that's required in order for you to begin to prepare to draft a trust? What does that look like?
So with a trust, there's a lot more digging into what assets are part of your estate. It becomes drastically important to know what you own and how you have it titled because it's got to be renamed to be owned by the trust as time goes on. One thing I have a lengthy conversation with all of my clients about is we need a full disclosure of all of that information because if we don't know it, it's going to be potentially subject to the court when you pass away. So if you don't retitle all of your assets properly into the trust, you're spending a lot of money on a trust that's not going to do you any good. So one thing that's really important in that initial meeting is finding out things like who the decision makers are going to be, who you want to receive things when you're gone, and how they want to do that. But again, with trusts, one thing that's very very different than maybe just a basic will is really digging into what you own and how it's titled.
All right, awesome. And then I think, one of the things that I see a lot, when people are coming into my office and they say, hey, I really want to do an irrevocable trust or some sort of asset protection trust. Can you talk a little bit about um, just generally what's the difference between an asset protection trust and there's like a whole category of these, right? You have your Medicaid asset protection trusts, your creditor protection trusts, a number of other types of trusts that people will talk about online. But what's the difference between that and a more traditional type of trust like a revocable trust?
Yep. The biggest word I use when it comes to this is the word control. Because when it comes to irrevocable trust, asset protection trust, all of that, when it comes down to it, the way you're going to get benefits from those types of trusts is by giving up control of the assets that you put into that trust and naming someone else to be in control of those assets. So with a revocable trust, you still get to be the boss and make all the decisions. You get to change it as often as you'd like. Really, no tax forms or anything like that are going to change. But with an irrevocable trust, what you're doing is you're creating a separate legal entity from yourself that someone else is going to be in charge of typically. And it's going to have its own tax return. And that's, some of the things that are going to provide that extra level of liability protection from those things is by you giving up control. In the eyes of the law, they're not your assets anymore. In the eyes of the law, they belong to the trust that someone else is in charge of. So, again, all the things that come along with that, like if you put your personal residence into a trust like that, you need to treat it as though you no longer own it. You need to be renting that from the trust and things along those lines. So the big difference is a revocable trust, they look at it as it's still you, where with an irrevocable trust, it's a separate legal thing away from you that's owning these assets.
Absolutely. All right. Yeah. And one thing I would flag, a lot of my clients come in and they're like, oh, I've got a business and I want to stick it into an irrevocable trust. And usually I say, hang on just a second, pause. Let's talk about, the tax implications. And as a tax attorney, I'm a big fan of saying, let's think about these tax implications. So, and just as a flag, we're talking exceptionally high tax rates for these irrevocable trusts, at the federal level. And it'll depend on the state for the state level, but at the federal level, you're talking tax rates that can go up to 37% on as little as a little less than $16,000 in income. So it's a pretty substantial tax rate hike on income. So if you've got income producing assets and you want to keep those assets inside of that irrevocable trust, it can create some pretty hefty tax burdens as well if you're not careful. So
And one
certainly
other thing,
something
when
to
you
consider.
say unless you're careful, one thing to consider is the trust can be drafted that the income gets passed out. But again, you have to be very detailed in how you do that so that that income gets allocated to certain people instead of the trust itself.
Exactly. And that is a non-trivial challenge because one of the things that I've found is nobody, at least nobody that I've met yet, has a perfect view of the future. Steph, have you ever met anybody who has a perfect view of what their future looks like? Because I'm not there yet.
No, I don't think so.
Okay. Yeah, and thanks for joining us, Steph. I know you've had a busy day in court, so I really appreciate you taking the time out of your day to get online with us here today and talk trusts. I know that it's always an entertaining set of conversations. So as far as let's get into kind of the point of this thing. So we're kind of talking about differences between Illinois and Georgia, and let's start with kind of the low level thing. You know. Say that I'm doing trust planning. Um, Big picture, what has to be in the trust? Ben, I'll start with you, and then we'll move from there. And let's talk about that, and let's also keep in mind the small estates thresholds as you talk about that.
So in Illinois, what's really important is making sure that just about everything is retitled into the trust, other than assets you haven't paid taxes on. So what I always say about that is 401ks, annuities, IRAs, those aren't going to be owned by the trust. Those are typically controlled by beneficiary designations. But outside of those assets, anything you put your name on should be in the trust. Because in Illinois, one of the big benefits to a trust is avoiding going through the probate process. And if you have assets in your name that total over $100,000, or you have any real estate that's in just your name, it's going to be subject to the court and the probate proceedings and everything that comes along with that. Now that 100,000 number will be switching to 150,000 coming in January. But again, what it is if you put everything into the trust, but the assets outside are under the $100,000, there's no need to go through the court process. Now, every so often, I deal with clients that they created a trust, they put their assets in, but then you find out that they had one account they didn't transfer in, and it was worth more than the 100,000. And then what ends up happening is it does revert back to the court process to get that account handled. Now, it doesn't mean everything becomes subject to the court process, but the assets that remained in the person's name do end up going through the court process. So it becomes, like I said, drastically important to make sure all of the assets ongoing as time goes on that are transferred into the trust whenever you open a new account or buy a new vehicle or something along those lines.
Yeah, and I think there's a change to law coming on that small estate threshold, isn't there?
Yep, just like I mentioned, that exemption, instead of it being 100,000 in January, it's going to go up to 150,000, which gives a lot more leeway, and it's less likely that, again, people are going through probate if that's the case. But again, if you consider a brand new pickup truck, I have some contractors that tell me they paid $108,000 for a brand new pickup truck. you can hit 150,000 still very easily. So it's just a very good practice to make sure things are being titled into your trust.
Absolutely. And Steph, we're talking about a small estate threshold in Illinois of 150,000. What does it look like in Georgia? I mean, what's the small estate, what's the limit on a small estate affidavit in Georgia right now?
In Georgia, it's 15,000.
So it sounds like a pretty big difference when you're doing trust planning down there on what you need to get into the trust. It sounds like you've got to be a lot more thorough down there. Is that a pretty accurate statement?
Yeah, that's correct.
Okay.
That's something I talk to people about too, is a lot of my Illinois clients, I say, if you want to keep a checking account or a vehicle outside of the trust, there's no problem because it can be, as long as we keep it under that 100,000. With it being only 15 in Georgia, you've got to run down to the DMV and get your titles switched over on your vehicles, or else they're going to have to go through the probate process.
And so I think the big takeaway here is, these small estate limits really kind of drive how we're doing planning and how we're selecting assets that need to go into a trust. It sounds like, Steph, when you're doing it, you've got to be a lot more thorough. Whereas, Ben, it sounds like you've got some leeway, and if there's a stray bank account or two, as long as there's not a lot of money in there, it's not like the end of the world. But with our Georgia clients, it sounds like we're having to be real detailed on that if we're doing the funding. I know that a lot of times, our clients elect not to have us fund their trusts. They don't like paying for the services, and I get it. But it sounds like it's something that's important, and it is something that is always important to do, is properly fund the trust. Because failure to fund, essentially, what happens, Steph? What happens if there's nothing in the trust when somebody dies?
So the way I explain this to clients is that a trust, until it's funded, is essentially an empty box. It has nothing in it and is effectively useless to you. And you actually need to fund it to move things into the box. So effectively, if it's not funded, it's just an empty box. It's useless.
Okay. So, and if there's stuff outside of the trust, then basically, what happens then?
What do you mean? If it's
If
below
it's
the 15,000 or
Yeah,
above?
what happens if it's below, and what happens if it's above? I mean, what do you do?
I mean, if it's below, it's less of an issue. If it's above, it's going to end up going through probate, which probably was the reason we set up the trust in the first place, was to avoid that. So, yeah.
It's a It's definitely, it's sounding, and just so people understand, I guess, let's kind of just talk probate for a second. In Georgia, Steph, I mean, what's your sense of probate in Georgia? I mean, is it a long process? Is it like 15 minutes in and out of court, or is it
No, it's like a
something?
year or two in and out of
Okay, so
court.
so
And
pr-
the
pretty
cost associated could be up to like 2% of the value of the estate just in court costs.
okay.
So,
Yeah. And Ben, I mean, I know people have thoughts about the Illinois court system being slow, but I know that sometimes I think we've got a summary administration option here, but if my memory serves, I think that's limited to $100,000, isn't it? It's basically almost at the same level as their small estate
Yep.
affidavit.
And if it's under the 100,000, it's just like we said, you'll be able to get it taken care of quicker. But if not, if you're going through the probate process, it's a minimum of 6 months, which typically what that means is it's somewhere between 9 and 12 to get it taken care of, as long as there's no issues. Any sort of issues that arise, whether that's somebody contesting the will, a bill you can't get taken care of, or something like that. And it easily starts getting up to, 18 to 24 months if that's the case.
And then as far as how we proceed, for trust administration, I mean, it sounds like there are some good options. Once the trust is created, somebody's passed, is that what happens to that trust? I mean, we have like this, um, we usually have a trust. We've got, do we still have to have a will if there's a trust? I mean, is that even necessary?
Yes, it is. I always call it my belt and suspenders kind of document. It's just in case there's anything else that's out there that didn't get put into the trust. It's there to help make sure that the trust ends up directing where it goes. So again, if somebody goes out and buys a new car right before they pass away or open a new bank account or something like that, or if they just literally forgot that they have an account that they didn't get in the trust, that will ends up filling in that gap and transferring it to the trust after they pass away. But it doesn't avoid that same problem with the $100,000 number. You could still potentially end up going through probate to use the will to transfer it all into the trust, but now you end up kind of doing double the work to get things taken care of.
Absolutely. And um, with regard to how a trust is actually administered, um, does a trust have to be filed with a court in Illinois?
No, and that's one of the really nice things about it. The entire probate process is a public process unless you have children involved. So, I mean, really, what you're looking at is the only thing that gets filed is a will that says, oh, you happen to have a trust. But the trust itself stays a nice private document that, nobody finds out that you disinherited children or anything along those lines. It just, everybody can kind of picture a nosy neighbor that wants to know everything about what they owned and who they left it to after they pass away. The trust is a really good way to make sure that, like I said, that nosy neighbor doesn't end up finding out anything after you pass away.
Yeah, and Steph, does Georgia support the idea of not having to tell your nosy neighbors publicly what you have with the trust?
Yes.
Um, trust administration, um, I guess let's talk about powers, that the trustee has, are the powers pretty limited typically in trusts? And I guess this is a good question for you, Steph. In Georgia, are you able to give your trustee power to sell real estate? Are they going to be able to handle your bank accounts for you if those bank accounts are inside of the trust? Are they going to be
Yeah.
able to pay your bills? Things like that. Can you kind of talk
Yeah, they're
about
able
what
to
they can
do.
do?
Yeah, they're able to do all that. I mean, like their authority is pretty expansive to act within the sort of guardrails of what the trust permits, but no,
Yeah.
they're able to act pretty broadly.
And when you're drafting these trusts down in Georgia, I know up here we have a pretty robust set of provisions that say, hey, if somebody's incapacitated, the trustee's allowed to use the trust funds for the benefit of, typically for the benefit of the settler. We may have some restrictions on that, but do you typically utilize something like that in Georgia as well, where where the trustee's able to continue to provide for the welfare of the trust creator?
Yes, we do have that.
Okay.
And
All
one
right.
thing I'll add in there too, James, is even when we do some of the more complicated tax planning and irrevocable trusts and things like that get put into place, one thing that does go into our trust is saying that that money is there for the benefit of both people creating the trust. So again, as long as one of them is alive, you're not going to have a whole bunch of money in some sort of tax planning device and the surviving spouse gets put out on the street because there's not enough money to pay for things. So yeah, there's definitely clauses that get put into the trust to make sure that both spouses are provided for, even if you start getting into some of the more complicated tax planning aspects of it too.
Yeah.
Yeah.
So,
I would also probably note that like the provisions in the trust are like very customized. Like I know that like the trust my mom drafted, my mom's an estate planning attorney in New York, and her trust stipulated that like the trust would not be used to pay for school if I got less than a B plus in any class that semester. So like there you can be very like specific as far as like how funds are to be allocated and at what sort of milestone markers, if that makes sense.
and
yeah.
and as well as naming who's in charge of making sure the person meets those milestones too. And one thing to go along with that stuff is some of the flexibility of, if somebody says, well, for your education, one of the new things nowadays is, well, what does that mean? Does that mean somebody
Hmm.
going to a 4-year university? Does it mean somebody going to a trade school? You
Right.
can be as specific as you want to be inside of that trust and name the person that has the discretion to decide whether or not they get those funds.
Hmm. Yep.
Yeah. So we had talked briefly about provision for spouses and trusts. What if you get a set of spouses who really just hate each other's guts? They want to they want to throw each other out. Let's start with a will. Um, and let's just talk will for a second. If they just did a will, in Illinois, um, would they be able to disinherit that spouse entirely, Ben?
But can I put a more positive spin on it? You know, a lot of times we get groups of clients that come in that maybe they're a later marriage in life and they each have their own kids. And they've discussed amongst themselves that, you know, the wife is going to leave things to her kids and the husband's going to leave to his kids. But just like you said, maybe it comes back to the point of saying, wait a minute, you didn't leave it to your spouse. So with a will, you cannot disinherit a spouse in Illinois. What it does is it allows them to, in essence, invalidate your will and make a spousal claim up to a third of the value of your estate. So they can really undo your planning if you're just using a will. Currently, the way the law is set up in Illinois, though, if you do a trust to do the same thing, there's no way a surviving spouse can challenge that. So again, it really depends on the way I always phrase it is, you know, when one spouse passes, a lot of times the kids get more vocal that all of a sudden, wait a minute, mom, you're entitled to more assets from him than when he passed away. Well, that may not have been the plan in the first place. So the trust can really be a way to actually effectuate what your real plan was at the beginning of the day.
That's fantastic. Um, Steph, I mean, and I guess, from a will perspective, can I, say that I moved down to Georgia, can I disinherit my spouse? Or can I have, like Ben said, maybe that plan that would intentionally not want to give something to the spouse and not have the kids come in and interfere with that choice in my will?
Yeah, I mean, Georgia doesn't like prohibit you from disinheriting a spouse. They do allow for the spouse to petition for a year of maintenance, which is like, I forget the exact number. It's not a lot of money, but yeah, in theory, you can disinherit a spouse
With a will or with a trust?
with a will.
Oh, really? That's interesting. Okay. Um, and to what extent, and I guess, um, and I imagine there are probably a bunch of asterisks and you have to really get detailed on that, with the language and everything else. But okay. Um, are there um, are there any things that, um, as people are crossing borders, let's say that somebody, with, maybe 10 or $15 million, they've got a small business that they've built from the ground up.
Well, is it 10 or 15? Because that makes a difference, right? If
Well, I guess,
the tax
let's say
threshold
10.
is
Let's say 10.
okay.
Well, we're below the federal limit, right?
Okay, beautiful.
Yeah, let's say that they're in Georgia and they pass away, with $10 million. Is there any implication at all of an estate tax or anything like that?
No, not in Georgia. There's no estate tax, just federal.
Okay. And then Ben, what about Illinois? Let's say that same person decides they want to move to Chicago and party it up in Chicago. I don't know why they would want to, but they do, right? They want to move up to Chicago, from sunny Georgia, and maybe they like the weather, they like the ice on the lake or whatever, right? So they move up and they establish residency, they get all settled in, and they pass away. What happens here?
So Illinois is significantly more complicated. Now, again, first of all, Illinois has what they call an estate tax versus an inheritance tax. So what it is they tax at the person's death whatever assets were attributable to their estate. So in Illinois, you can have up to $4 million without paying any Illinois estate taxes. Now, again, you still deal with the $15 million federal exemption once that comes up. But again, one thing that's drastically important in Illinois is they do not have what they call portability. So federally, if one spouse passes away and only has $1 million in their name, the rest of that $14 million exemption can transfer over to the surviving spouse. In Illinois, they do not allow that. So if that same spouse passes with only 1 million, the other $3 million of their exemption just disappears. So what's drastically important is just kind of splitting up the assets between the spouses. So, if you create a his trust and a hers trust, what's really important is balancing those out. What I do quite often is I do joint trusts for married couples with tax planning in there to allow them to decide what gets attributable to the deceased spouse and what gets attributable to the surviving spouse. Because again, when that first spouse passes, you can push up to $4 million into their estate without paying any estate taxes. So it's drastically important to make sure what gets included in the first spouse to pass away's estate and the second, just because of the not having any of those, not having the portability in Illinois.
Absolutely. Thank you. All right. I think, we could go on this topic for a couple days, but I think we're going to cut it off here because I know that we all have other commitments. But I'd like to thank everybody who is watching this video in the future or listening to the audio on our podcast. My name is James Greenwood. I'm an attorney licensed in Illinois and Iowa. Joining us is Mr. Benjamin Young, an attorney in Illinois and licensed in Iowa as well, and attorney Dr. Steph Acello, excuse me, who actually does have a PhD. So we will call Dr. Steph Acello, and licensed in Georgia as an attorney. Responsible attorneys here are Steph Acello, James Greenwood, and Benjamin Young. If you have questions or concerns about today's episode, you can call us at 855-528-6022 to let us know. Thank you so much for joining, and you have a great day. Goodbye.